Travis Rudolph.
All rise. Third court is now in session. The Honorable Jeffrey Gillen presiding.
Okay, good afternoon, everyone. Go ahead and take your seats.
Moment of truth, y'all.
I know Deputy Lubinsky is always diligent in this regard, but I'm going to make sure that everyone understands. I have no idea what the verdict is going to be in this case. Zero, none whatsoever. However, some of you may be happy, some of you may not be happy. Do not, under any circumstances, express your displeasure with anything that's gone on in this during the course of this trial or with the verdict when it is rendered. If you got to think about things and say things, you can do that on social media or any other way you wish, but there will be no violence allowed in this courtroom. There will be no violence allowed in this courthouse. There will be no confrontation, no loud, obnoxious behavior. You maintain your civility, ladies and gentlemen, at all times. Remember, we are all human beings. We all must live with one another, and that is the way you're going to behave in this courtroom and in this courthouse.
Who's he directing that at?
All right, any reason why we
Everybody.
can't bring the jury back into this room right now?
No, sir.
All right, thank you. Let's bring them in, please.
He's directing it at everybody. No shenanigans. Russell says, quick verdict equals guilty, Murdoch and Anderson. Just got the tweet notification for the verdict from Jess Rubery. Thank you so much. Matthew Self says, normal people in the jury are thinking those hoodlums asked for it. Don't go beating up people at their houses. We're about to find out. Peace Peony says, can the jury ask for transcripts of testimony?
All right,
Love this crew today. Thanks for hanging here with us, Jeff. Well, we're about to find out. It doesn't matter. They don't need the they don't get the transcripts of the testimony, by the way. They just get their notes. But they are back. Here we go. We will sit here quietly and find out.
All right, welcome back, everyone. Go ahead and take your seats. I am given to understand, ladies and gentlemen of the jury, that you have reached a verdict. Is that so? All right. Will the foreperson please hand the verdict form to one of our deputies? Deputy, somebody. Mike, would you go get that for me, please? Would you publish the verdict, please?
In the Circuit Court of the 15th Judicial Circuit Criminal Division in and for Palm Beach County, Florida, case number 21 CF 002938 A and B, Division W, State of Florida versus Travis Rudolph. Defendant, verdict. We, the jury, find as follows. As to count one, we find the defendant not guilty. As to count two, we find the defendant not guilty. As to count three, we find the defendant
What's up, Ozzy?
not guilty. As to count four, we find the defendant not guilty. So say we all. The 7 days.
Absolutely not guilty across the board.
Would either side like to have, would either side like to have the jury polled? All right, thank you. Ladies and gentlemen of the jury, I, on behalf of everyone who is a participant in this trial, would like to thank you for your time and your consideration. I also wish to advise you of the special privileges enjoyed by jurors. In the absence of a court order, no juror can be required to talk about the discussion that occurred in the jury room. Our judicial system relies on juries for consideration of difficult cases. We recognize that a jury's deliberations, discussions, and votes should remain their private affair so long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyers and their representatives are not permitted to initiate any communication with you about the trial. However, you may speak to the lawyers or anyone else about the trial if you wish. In the absence of a court order,
Look at all those
you
bailiffs.
have the right to refuse to speak with anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror. I will add that I know that there has been a great deal of publication about this case. You need to keep that in mind. It's very possible you will be contacted by individuals.
If any of you want to come on my channel, hit
that
me
I
up.
just read to you.
You are welcome.
Ladies and
here.
gentlemen, I'm also now going to pass out to you letters identical to those which I've given your colleagues, the two alternate jurors whom I excused earlier in the afternoon, or I guess it was morning. I would encourage you, please, to take the time. It won't take you more than a minute or two, well, maybe 3 minutes to fill out those questionnaires. I do, as I said before, I do take them very seriously. I look at them. I have made changes in the way in which I conduct jury trials and the manner in which I handle juries and jurors based on those responses to those questionnaires over time. So please take the time to fill those out and then throw them in the envelopes that have been pre-addressed and postage paid for you. Thank you, ladies and gentlemen. Once again, I know it's been a long time, a long process, and I thank you very much for your time, consideration, and work. You are relieved.
Outstanding.
Wow. There you go.
So what's the likelihood now that the in my opinion, true perpetrators of crime in this situation get charged?
I think they're past the statute of limitations.
Oh, are they really? Okay.
If my understanding is aggravated assault is a 2-year, I could be completely wrong in Florida.
Felony
This was
murder.
April
can't-
20.
All right, everyone, take your seats.
It would be how they look at it.
Seems to me there are a couple of things we need to address, but I may be mistaken about that. So I'll turn first to Mr. Shiner. Is there anything I need to address so far as your client is concerned? Okay, well, that will be done. You will, of course, yeah. All right, that's already done, as a matter of fact. That's what I was thinking about. Let me talk to the state about that. Right. Okay, so he is not physically in custody of the sheriff's department, and that would be a different procedure. Now that he is on in-house arrest, do you know how he is taken off the monitor?
Judge, he would just need to contact whoever he's reporting to.
Okay.
Contact whoever he's reporting to, whoever he's set up the in-house arrest with, and they would, either him or Mr. China, have the ankle bracelet removed.
I think that's the first time I've seen a law and crime chat happy that someone's not guilty.
I will not do that. All right, but I will authorize you immediately, get on your cell phone right now if you want, and contact whomever it is that's responsible for that and tell them that I have ordered that his monitor be removed. All right, anything else from either side?
Judge, I'm going to file a motion. It's not appropriate to do it now to return property. I'll file that motion.
All right, very well.
We'll get to your
Anything else?
For chats here in a
All
bit.
evidence to be returned to the parties.
No. The evidence is going to be kept by the clerk's office until such time as a motion is filed, particularly with respect to firearms. All right? All right, thank you. Anything else?
Give that man his guns
Okay,
back.
thank you.
USA.
Stay
USA.
calm, everyone.
That's the first
Stay
thing.
calm.
Get the ankle monitor off and give him his guns back.
And more importantly, stay safe.
Ginger is going to file a motion for the return of the firearm.
Why the fuck am I so relieved when things go the way they're supposed to go?
Because they
There's
haven't
been so many
going-
instances in the last however many months that have just been ridiculously out of proportion.
We've watched too many of these things go the wrong way in the last year or two. Good for you, Travis. Get it, brother.
That's a happy man right there.
Yes.